Okay, welcome back again to Native American history courses. So we've just covered the War of 1812, and what we're really gearing up toward is this major decision in the U.S. courts. And I can't stress this enough, partly because it only gets mentioned kind of in brief in a lot of Native American history books, but at least people who are in the field who are working, from my perspective, we're seeing that this is one of the most foundational decisions, even though, of course, it's the colonizer government, it's the US government who are making these decisions. There, it is this decision in 1823's Johnson v. McIntosh that continues in 2025 to determine many of the uh, legal decisions that the US has in relationship to Native people. And then in the broader atmosphere, when we're looking back at this and we're thinking about, like, well, what is law? What is law itself? Like, just because the law says something, does the law really um, determine what society thinks? Like, what do regular people who were living at the time, what did they think about about this stuff? But what we see and what I would suggest over time is, like, yeah, maybe the law doesn't always reflect everything, but over time there is this kind of correspondence, right? Like, we know that the idea of whiteness, which I've talked about in earlier lectures, it is a legal concept. And yet, most people, when they're talking about race, or comedians, when they talk about race, they're not thinking of it like, oh, well, you know what this US Supreme Court says about that, sort of blah, blah, blah. But when we think back on the animosity, when we think about, like, the way that racial politics have shown up in this country, it's because of this apparatus of power that does do this kind of defining thing in relationship to race, which is, of course, a social imaginary. There's no biological kind of basis for race, right? And issues of even categories of race have their own history. So what constitutes whiteness in 1700 is maybe not the same thing that constitutes whiteness in 2025, right? But even though we know that biologically there's no significance to race, that doesn't mean that race as a social imaginary doesn't play a role in many of our lives. I would say basically all of our lives. And some people more than others, right? Like, some people have to think about, because of their own situation, have to think about their racial formation every day. And some people are privileged enough that they don't have to think about it. And then they get all up in arms when people want to talk about it, or they want to say, like, like, let's just get beyond it altogether, right? That kind of thing. That's like wishful thinking, right? Because it's entrenched in our legal systems, and that we've already seen from the Declaration of Independence and the U.S. Constitution and the Citizenship Act of 1790, these types of ideas showing up. Now, what makes Johnson v. McIntosh so important in 1823 is that it becomes foundational for, first of all, incorporating doctrine of discovery from the papal bulls into U.S. law. Now, the papal bulls of discovery were foundational to Catholic Christian politics, right? And then we get this Protestant Reformation, and we get all this drama in England about, like, the Puritans and their own revolution in the 1640s and 50s, and the Anglican Church. So we're having state-based religions that are Protestant in formation, but then we have more extreme Protestants that, of course, are coming over, and some of them are trying to found the so-called New Jerusalem, the Puritans, and all of that sort of stuff going on. So even while Anglo-Americans generally have a real allergy or hatred of the Catholic Church, they still use the rhetoric of papal bulls of discovery in order to justify their own presence here. And that especially happens with the four English colonies, not just in the United States, but in Canada. United States, New Zealand, and Australia. And we just, in this course, we're not talking about New Zealand and Australia, but this case becomes foundational. It becomes cited in different legal systems as well. Another case, or not exactly case, but a political doctrine from 1823 that you might have heard of is the Monroe Doctrine. So we have James Monroe as president, and he develops this doctrine, which is directed at foreign powers, and particularly in relationship to South America, where the Monroe Doctrine says that if any foreign nation attacks any country in South or Central America, the United States is going to consider it as an attack on themselves. Um, and in a way, that might sound on the one hand like, oh yeah, like the US is standing up for all of its Latin American neighbors. That term Latin America doesn't quite exist yet. It actually emerges out of the Monroe Doctrine fallout. But we see these different independence movements in Bolivia, and like Simon Bolivar down in Bolivia and Venezuela and Colombia, right? You see this wave of independence movements in the 18 teens. You see Mexican independence showing up, right? And these are places that have been inspired by the United States and the American Revolution. But from their perspective, right, down south, they look at the United States and they're like, what are you doing? Right? Why would the United States say that any attack on their nations is going to be an attack on them if the United States didn't already perceive South America and Central America as its kind of backyard, as something that it has dibs on, even if it's not yet part of the United States. So there's that aspiration to empire, and reacting to the United States in that way means that what we have are a lot of these independence movements throughout South and Central America that have varying relationships with the Catholic Church, but they nevertheless trace their attitudes back to Rome. And that's where we get this concept of Latin America coming from. Of course, what it means to be Latinx or Latino today is different up here in the United States, and might mean something different. If you're from South America, you might not understand the politics of the use of those terms. If you're from Guatemala, the term Ladino is not necessarily a good term, especially from a native perspective. It's what they call the colonizers, or the Euro-Christians down there. So, yeah, all sorts of different language that people use around um, the idea of Latin America, but that idea as a political entity, it really happens in reaction to the northern continent here, kind of setting its sights on South America and saying that it has dibs on it. And that continues all the way into present times, right? Right. In recent years, the US had a hand um, uh, uh, in Bolivia. It still has hands in Venezuela and Venezuelan politics. And it's a long tradition, right? Going back, I mean, even the 18 or the 1950s with the overthrow of the democratically elected Guatemalan government, right? And in the early 70s with the overthrow of Pinochet in Chile, right? And the installation of dictators that are favorable to the United States. So that kind of foreign power um, impulse, like we might call it also an impulse to empire itself, but definitely the United States' relationship to international bodies, it's kind of a two-pronged fork from 1823. It's like on the one hand, we've got the Monroe Doctrine on the domestic side of things in relationship to Native peoples up here. We see this famous case, Johnson versus McIntosh. The main scholar, one of the who has a great book on this, is Lindsay Robertson. And if you're in my classes, you'll see that I've put in a podcast episode from the Doctrine of Discovery podcast with Lindsay Robertson so that he can talk about this stuff because he knows it so well. And his book is really good. I've read his book. on it. So there's a lot to be said about how the formation of the Supreme Court happens from the 1790s all the way up to 1823, how Justice John Marshall builds the power of the Supreme Court. But what happens to keep it as brief as I can today is that in 1823, this case is brought before the Supreme Court. Now, no natives are even part of this case, and that's something to remember. Like this is just Euro Christians and other Euro Christians wanting the court to get a decision. And so you have these two, that's called a faux case. And what happens in law is that when a faux case happens, it establishes legal precedent for other things to happen. So on the two sides of Johnson v. McIntosh, one party claims that it had bought land directly from native people. The other side claims that it has the right to go in and set up a colony because of a relationship to the United States. And what the decision says, in a nutshell here, is that Native Americans can never sell land to anyone because the Native Americans don't own the land to begin with. They don't have title to the land. Title to the land is held by the United States government, which inherits it from the rights of discovery from the papal bulls that it inherited from England when it was at the time of the American Revolution. So whatever colonists are out dealing with like a native group and saying that they paid for this land that they're squatting on, the United States will not recognize that because the United States says that that as an entity, the US government owns all of the territory and it basically leases out in the form of property different settlements and eventually states. So it says that the Indians have a right to live there, though. So they have a right to occupancy in the same way that maybe if a rabbit or a squirrel is running through your backyard, it has the right to live there. Birds can make nests, all of that sort of thing, but the natives cannot have any claim to owning the land itself. It's a massive legal decision. Of course, you can already tell that this is like has horrific effects for Native peoples. And it's also based on this legal fiction. It's based on this legal fiction that the reason why the United States gets to have these rights is because it acts as a Christian nation. And it going back to the papal bulls of discovery, like any land that's not claimed by a Christian prince can be claimed for that Christian prince. So there is no recognition of indigenous peoples by the Euro-Christians. That's why we need to have that Euro-Christian perspective in order to understand American Indian worldview or Native American worldview and Native American history, because it still continues on to this day, as we've said in earlier lectures, right? It's still being cited by the US Supreme Court in the 21st century doctrine of discovery as being foundational to uh, claims about land for native peoples, right? So, City of Sherrill versus Oneida is the famous case where Justice Ruth Bader Ginsburg, who's considered to be this like great feminist and liberal person in some respects, she's the one who cites Johnson v. McIntosh, and that's a Supreme Court case, but it also gets cited in district court cases as well. So the rest of this lecture, you should read through the court case, but it's long too if you're a student. And so this is just to help guide you through the thinking here that the Euro-Christians have. And it's a legal fiction that's being made up. And maybe you should ask yourself, as I always ask my students, what would, you know, We generally, as US citizens, think that there should be a separation of church and state, and yet we have this law that founds all property law in the United States today, not just for Native Americans. It's a case that founds property law for like all real estate transactions. So, as I'm told, I don't have a law degree. As I'm told, you study Johnson versus McIntosh oftentimes in the first year of law school. But they don't often focus on the way that Native Americans are being deprived from the land, which says a lot about what people focus on in law school. So here's all of these passages in this PowerPoint slide are taken directly from John Marshall, who's the head of the Supreme Court in 1823 in his decision. He says the Indians remain in a state of nature and have never been admitted into the general society of nations. Now, any philosopher, if you're a philosophy student, you will know that Thomas Hobbes and Jean-Jacques Rousseau and even John Locke use this idea of the state of nature. And John Locke says that in the beginning, all of the world was America, in the sense that people weren't transacting through money. All the world was in a state of nature. So the Euro Christians have a linear sense of history and a linear sense of time and development over time. They believe that their Christian civilization is better than ever. It's the most evolved sense in the whole world, and evolving with it is economy and money and commerce and all of that sort of thing. And people outside of that are somehow back in time. They're backwards and they live in a so-called state of nature. But when you look at philosophers, even in Thomas Hobbes, he says there maybe wasn't really an exact time. Even Rousseau says this. Maybe there wasn't an exact time when everybody was in the state of nature, but it's a hypothetical idea that we use for human civilization. But when we actually look at court cases like this is like case in point, right? That when we look at dealings with Native American peoples, the state and government uses a philosophical hypothetical idea of like the state of nature and to directly affect Native American peoples, right? So it's not hypothetical anymore, right? And I've been in professors' classes as a graduate student who said, "Oh, it's just a hypothetical thing," and it's like, yeah, it's only a hypothetical thing until you are having your land taken away from you because a law actually says that you can't have it because you live in a state of nature, right? So all the treaties and negotiations between the civilized, let me just go back to the beginning here. The Indians remain in a state of nature and have never been admitted into the general society of nations. All the treaties and negotiations between the civilized powers of Europe and this continent, from the Treaty of Utrecht in 1730 to that of Ghent in 1814, remember that's the 1812 war, the end of the war, although Andrew Jackson keeps fighting down in the Battle of New Orleans. Um, to the Treaty of Ghent in 1814 have uniformly disregarded their supposed right to the territory included within the jurisdictional limits of those powers. Not only has the practice of all civilized nations been in conformity with this doctrine, but the whole theory of their titles to the lands in America rests on the hypothesis that the Indians had no right of soil as a sovereign as sovereign independent states. Discovery, this I have it up in bold, right? Discovery is the foundation of title in European nations, and this overlooks all proprietary rights in the natives. That is like a key phrase, right? When people say, "Oh, like the people, Europeans were here before Columbus. He didn't discover anything." It's like, yes, he didn't. Yeah, Europeans knew, like the Vikings knew about being here. But what we're getting at in this course is that it's the papal bulls of discovery, and these are Euro-Christian rights of discovery that build into legal apparatuses, and they found the nations as they continue to exist to this current day. Now, we could ask ourselves, is there a way to undo that? Maybe it seems like maybe the claims to our right to have the government work shouldn't be claimed shouldn't be based rooted in Christianity, right? That's something that you can think about philosophically, and maybe so. You know, we sometimes overturn really old laws like Plessy versus Ferguson, which established segregation in this country for a long time. That gets turned over. Roe v. Wade was law of the land. Abortion was law of the land for over 50 years, and then it got turned over. So, like, maybe a question to ask yourself as a student is like, what would it mean? What would it mean in the United States if there was a current impulse? And this happens for in Native American activism today. So, bringing it all the way to the present is like, what would it mean to overturn this court case, Johnson v. McIntosh? What would it mean for Native peoples? What would it mean to our own sense of property claims? So let me go on with extracts from the case here. Even if it should be admitted that the Indians were originally an independent people, they had ceased to be so. A nation that has passed under the dominion of another is no longer a sovereign state. The same treaties and negotiations uh, before referred to show their dependent condition, or if it be admitted that they are now independent as foreign states, the title of the plaintiffs would still be invalid. So even if you said, like the Cherokee, for example, who are going to come up with in removal, even if you said that the Cherokee have their state isn't founded on their own sovereignty, it's invalid because the entity that owns the actual land is the United States. And so only the United States can grant title to the land. Um, as grantees from the Indians, they must take according to their laws of property and as Indian subjects. The law of every dominion affects all persons and property situate within it, and the Indians never had any idea of individual property in lands. And this is actually kind of true, right? Like property is a Euro-Christian idea that comes from that baptizing the land and then renaming it that Columbus was doing. So it's not like John Marshall is completely wrong in this, right? And John Marshall, in some ways, is sympathetic to that the Indians have the right to occupancy until they decide to give it up in a treaty alliance. But what they can't do is they can't sell, like the Cherokee can't sell part of their land to just some white speculator, right? Or Euro-Christian speculator. That has to be done through the US government. He says because the grantees could not take sovereignty and eminent domain to themselves. So this idea of eminent domain, if you go into property law, that becomes this. That's where this case informs all of that stuff too. More extracts here. It's unnecessary to show that they are not citizens in the ordinary sense of the term, the natives, right, and Indians. And notice how he's using the term Indians in general here. He's collapsing all Indians, all native people into just one category of Indians. Now, we'd seen pan-Indian movements with Tecumseh, right? Um, but it becomes important because sometimes in politics today, people say, "Look, oh, don't use the term American Indian or use Indian." It's like we have to use Indian still in a legal sense because that's the way that Native people are being referred to in the documents that become the foundation of what we now call federal Indian law. So he says it is unnecessary to show that they are not citizens in the ordinary sense of the term, since they are destitute of the most essential rights which belong to that character. They are of that class who are said to be by jurists not to be citizens, but perpetual inhabitants with diminutive rights. The statutes of Virginia, the colony of Virginia, before it becomes a state, right? Remember, that's where we see whiteness emerging. The statutes of Virginia and of all other colonies and of the United States treat them as an inferior race of people without privileges of citizens and under the perpetual protection and pupillage of the government. The Act of Virginia of 1662 forbade purchases from the Indians, and it does not appear that it was ever repealed. So notice how Johnson here, not Johnson, excuse John Marshall here is basing his own legal precedent not within American law, but within colonial Virginia law, that would have been British law, like in the colonies, right? So if the United States, his sense of the inheritance of the United States comes directly from British law. But then he goes on and he cites what would be international law at the time. So these are the major theorists of international law, Hugo Grotius and Vattel. These statutes, he says, seem to define sufficiently the nature of the Indian title to lands, a mere right of usufruct and habitation without power of alienation. They can't kick people out of their land. By the law of nature, they had not acquired a fixed property capable of being transferred. The measure of property acquired by occupancy is determined according to the law of nature, by the extent of men's wants and their capacity of using it to supply them. It's a violation of those rights of others to exclude them from the use of what we do not want, and they have an occasion for it. So he's citing these international European theorists, right? Then citing John Locke, English philosopher, and Montesquieu, French philosopher of the Enlightenment. He says, according to every theory of property, the Indians had no individual rights to land, nor had they any collectively or in their national capacity, for the lands occupied by each tribe were not used by them in such a manner as to prevent their being appropriated by people of cultivators. That's a word from Locke, John Locke, cultivating, moving up, that something has to be done to cultivate the soil to make it. Then John Locke's labor theory of property, you make property your own if you've somehow improved the land. Going on here. All the proprietary rights of civilized nations on this continent are founded on this principle. The right derived from discovery and conquest can rest on no other basis, and all existing titles depend on the fundamental title of the crown by discovery. The title of the crown as representing the nation masked to the colonists by charters which were absolute grants of the soil, and it was a first principle in colonial law that all titles must be derived from the crown. It is that true that in some cases purchases were made by colonies from the Indians, but this was merely a measure of policy to prevent hostilities. So when we look at New England, where people were purchasing, making agreements, basically John Marshall is saying that was just like to get access to the land and prevent hostilities. And it really didn't have any like real bearing. So he says William Penn's purchase, which becomes Pennsylvania, right? Which was the most remarkable transaction of this kind, was not deemed to add to the strength of his title. Now he gets to the Royal Proclamation of 1763. He says, if the Indians are to be regarded as an independent sovereign states, then by the Treaty of Peace, they became the subject of the prerogative legislation of the crown as a conquered people in a territory acquired jure belli, just war, or sorry, by right of war or conquest, and ceded at that peace. If, on the other hand, this country be regarded as a royal colony, then the crown had direct power of legislation, or at least the power of prescribing the limits within which grants of land and the settlements should be made within the colony. The same practice always prevailed under the proprietary governments and has been followed by the government of the United States. So he's thinking here, you can hear him like you can feel him thinking about the Louisiana Purchase, about the recent winning in 1815 of the War of 1812, as the right of society to prescribe those rules by which property may be acquired and preserved is not and cannot be drawn into question, as the title to lands especially is and must be admitted to depend entirely on the law of the nation in which they lie. Now remember, the nation as a kind of newish concept, right? Like we start getting the modern nation state like really like showing up like when we think back to the so-called Peace of Westphalia in 1648 and the modern nation state. So this is all kind of In a way, this is like he's doing a lot of inventing here. It will be necessary, he says, in pursuing this inquiry to examine not singly those principles of abstract justice which the creator of all things, i.e., the Euro-Christian God there, has impressed on the mind of his creature man. So, of course, he's got this biased Christian perspective, right? And which are admitted to regulate in a great degree the rights of civilized natives who perfect independence is acknowledged, but whose those principles also which our own government has adopted in the particular case and given us as the rule or for our decisions. So part of what's kind of murky in there is again this idea of the status of a civilized nation, and this is exactly what the Cherokee have been trying to do. Is they're like there's this new kind of like nation state discourse that's going on, and the Cherokee decide, okay, we're gonna like. Do you think that we need to read and write in order to be civilized? So we'll invent a writing system. We'll write our own constitution. We'll start our own newspapers. We'll use property. We'll even own slaves. With the Cherokee owned slaves and plantations and all of that sort of stuff. They adapted everything that they could think of to try to be considered civilized according to the Euro-Christian standards. And yet they still get removed, right? So that's what we're leading into in the next lecture. But this is what like this word, fancy word, imbrication, right? It's like the pulling in of discovery in US law. Uh, on the discovery of this immense continent, the great nations of Europe were eager to appropriate to themselves so much of the land as they could respectively acquire. Its vast extent offered an ample field to the ambition and enterprise of all, and the character and religion of its inhabitants afforded an apology for considering them as a people over whom the superior genius of Europe might claim an ascendancy. It is the religion of the native peoples being not Christian that allows the Euro Christians to claim an ascendancy over them, right? The potentates of the old world found no difficulty in convincing themselves that they made ample compensation to the inhabitants of the new by bestowing on them civilization and Christianity in exchange for the unlimited independence. So, this is the thinking. Yeah, all of your lands and your cultures get taken away, but we've given you Christianity in exchange, and you should be happy about that. But as they were all in pursuit of nearly the same object, as all the European powers were all in this pursuit of the same object, it was necessary, in order to avoid conflicting settlements and consequent war with each other, to establish a principle which all should acknowledge as the law by which the right of acquisition, which they all asserted, should be regulated between themselves, only between Euro-Christian European powers, right? This principle was that discovery gave title to the government by whose subjects or by whose authority it was made against all other European governments, not against other native governments, right? Which title might be consummated by possession. Continuing on. Indians were admitted to be rightful occupants of the soil with a legal as well as a just claim to retain possession of it and to use it according to their own discretion, but their rights to complete sovereignty as independent nations were necessarily diminished, and their power to dispose of the soil at their own will to whomever they pleased was denied by the original fundamental principle that discovery gave exclusive title to those who made it. Who made it. Now, this is a legal theorist, John Marshall, head of the Supreme Court, kind of making this all up. It's a legal. We're witnessing the creation of legal fiction in action here. But at least he's giving us a rationale for it, even if we don't agree with it today. Then we can say, like, well, you know, uh, is the foundation of the United States and its right to take land from native peoples based on Christianity to begin with. It seems like that's what this court case is saying is the case. Um, so here he says Spain did not rest her title solely on the grant of the Pope. Her discussions and respecting boundary with France, with Great Britain, and with the United States all show that she placed it on the rights given by discovery. So look at the way that John Marshall is getting around the Catholic Protestant divide here, right? He's not saying that the Pope has like power, even though at the same time he's claiming that doctrine of discovery from papal bulls is what grants the US the right. What he's saying is that the European powers, who are all Christian, decided through basing their right to rule on discovery that they would respect each other's rights, whether they were Catholic or Protestant or whatever, so long as they were all Christian. So this is how he's getting away with like not saying that the Pope has power, right? Because he's from an Anglophone, an Anglo tradition, right? Portugal sustained her claim to the Brazils by the same title, he says. The claim of the Dutch was always contested. That would have been early New York or New Amsterdam by the English, not because they questioned the title given by discovery, but because they insisted on being themselves the rightful claimants under the title. So their pretensions were finally decided by the sword. So then we get into these like conquest, just as like, is it conquest that gives rights or is it discovery that gives rights? Becomes part of international law discourse among the Euro Christians. He says no one of the powers of Europe gave its full assent to this principle more unequivocally than England. So sorry, when I copy this stuff from the old documents, they're PDFs, and it screws up some of the letters. That's why you're seeing the weird typos and stuff here. Also, spelling is just all over the place when you're looking at old documents. He says the documents upon this subject area are a example and are ample and complete. So early as the 1496, and that should probably be year 1496, England's monarch granted commission to the Cabots, to John Cabot, to discover the countries then unknown to Christian people and to take possession of them in the name of the King of England. 2 years afterwards, Cabot proceeded on the voyage and discovered the continent of North America, along which he sailed as far south as Virginia. So again, he's distinguishing that the North America belongs to the Protestant Christians who had broken away from the Catholic Church and the Anglican tradition, right? And then the Puritans and more extreme Protestants after that. The ceded territory, he says, was occupied by numerous and warlike tribes of Indians. There's that idea, oh, they were just all fighting amongst themselves. They were just wanting to have war. They needed civilization to be brought to them. That's part of the Euro-Christian rhetoric. But the exclusive right of the United States to extinguish their title and to grant the soil has never, we believe, been doubted. We will not enter into the controversy whether agriculturists or merchants or manufacturers have a right on abstract principles to expel hunters from the territory they possess or to contract to their limits. Conquest gives a title which the courts of the conqueror cannot deny, whatever the private and speculative opinions of individuals may be respecting the original justice of the claim, which has been successfully asserted. So the winnings of the War of 1812 would then be granted to the U.S. by conquest, no matter what, if they're squatters who are already been there, who've been dealing with individual native tribes, right? So then again, we have this kind of that conflict between the kind of regular colonizer Euro-Christian and then the colonizing governments as well, which we saw in tension all the way back in Bacon's Rebellion as well in an earlier lecture. So he says, although we do not mean to engage in the defense of those principles which Europeans have applied to Indian title, they may, we think, find some excuse, if not justification, in the character and habits of the people whose rights have been wrested from them. Humanity, this reference, humanity, however, acting on public opinion, has established as a general rule that the conquered shall not be wantonly oppressed, and that their condition shall remain as eligible as is compatible with their objects of the conquest. So here John Marshall is saying that just because the U.S. has the rights of discovery doesn't mean it can just kick Native people out. That's going to be really important for when we look at removal in the next lecture. Most usually, they are incorporated within a victorious nation and become subjects or citizens of the government with which they are connected. So, how do they get it? Because they become civilized, right? So, this is the approach at the time period. Um, Once Indians are civilized, they just assimilate and become part of the body politic of the nation state. The new and old members of the society mingle with each other. The distinction between them is gradually lost, and they make one people. Where this incorporation is practicable, humanity demands, and a wise policy requires that the rights of the conquered to property should remain unimpaired, that their new subjects should be governed as equitably as the old, and that the confidence in their security should gradually banish the painful sense of being separated from their ancient connections and the U.S. To and united by forces to strangers. So there is some sympathy, of course, that John Marshall has for Native peoples occupying their lands, and that's going to set him at odds with Andrew Jackson, who wants to remove all Indians, right? So just war, I have a question mark here, but of the tribes of Indians having inhabiting this country were fierce savages whose occupation was war and whose subsistence was drawn chiefly from the forest. To leave them in possession of their country was to leave the country in a wilderness. To govern them as a distinct people was impossible because they were as brave and as high-spirited as they were fierce and were ready to repel by arms every attempt on their independence. This is complete made up BS that the Indians are all savages that we've seen going on since the early contact with Indian. The more or, with Indians, like by especially by the English, right? And that word savage becomes even more pointed with the development of New England. The more savage you can make the Indians, the more you can say that they're always just fighting amongst themselves, the more they needed civilization to be brought to them, the more it just justifies the conquest itself. Then we get whiteness again in language here. Indians versus whites. Frequent and bloody wars in which the whites were always the aggressors unavoidably ensued. European policy, numbers, and skill prevailed as the white population advanced. That of the Indians necessarily receded. So there's this sense that, like, again, you can see embedded in the language. Here's the idea that white people are just somehow inherently more sophisticated. Um, So too, he says, with respect to the concomitant principle that Indian inhabitants are to be reconsidered merely as occupants to be protected indeed while in peace and in possession of their lands, but to be deemed incapable of transferring absolute title to others. He says it's never been contended that the Indian title amounted to nothing. Their right of possession has never been questioned. They can live there, the claim of the government extends to the complete ultimate title charged with its right of possession and to the exclusive power of acquiring that right. So this 1823 Johnson v. McIntosh decision is going to then found what we call federal Indian law because the U.S. Constitution says Congress will deal with all actions of trade against Native peoples. But Congress also deals with native nations in terms of a treaty to treaty or a nation to nation agreement. So what's being fudged here or what's being muddied here is that distinction about whether or not Native Americans are actual nations, even though treaty relationships imply that it's a nation to nation agreement, and plenty of treaties have already existed by this time. So this new discourse on nations and what constitutes a nation and what constitutes a people is being manipulated, to say the least, by John Marshall in order to justify the U.S. government's uh, rights to discovery, which is inherited from the Euro-Christian tradition, and which the Indians don't have essentially because they aren't Christians to begin with. But once they become Christianized and civilized, they can just assimilate and join the new society itself. He does not believe that Native people should be automatically moved out. And so this is something that happens in the racism that shows up among Euro-Christian philosophers throughout the period. So another philosopher, a German philosopher, Immanuel Kant, for example, who's often thought of as a father of human rights law. When you actually read Kant, he thinks that non-white people, non-European people, because of their lack of Christianity and their lack of civilization, that they've never produced any like good art or anything. Now, he doesn't say that you should just go in and then does that mean that you just have a war of extermination against all of Africa, for example? He would say no, that would be cruel. But he does go on to say, and this is his racism, and this has been very much in a lot of continued philosophy. The idea is that, like, well, the non-white or non-Euro Christian nations of the world, they will eventually just die out. They'll die out naturally. You don't need to like go and be mean to them, but they will die out because they're somehow lesser to begin with. So that kind of sentiment is going on in Europe, and it's definitely inflected and being manipulated in its own ways in the US government at that time. I'm going to stop now and we'll continue with Indian removal in the next lecture.